for pronouncement of judgment.
Writ petition, PIL petition not maintainable as it relates to service matter.
Item 70.
Co warranto PIL petition maintainable.
Adjournment request, if any, from item number 1 to 27.
Item number 25, Madam, I'm seeking a week's time.
Delay condonation, no further additional date.
Madam, item,
And counsel for the applicant pays for and granted a week's time to file further affidavit. List after a week.
item number 49, my lord. Item number 49 is a appeal by the state where we had alleged fraud on the part of the writ petitioner while getting the writ petition disposed of. We had lodged an FIR, it has been charge sheeted, and the trial is going on. Could it be after the vacations, my lord, we'll have the evidence on record in the trial court? I had apprised the counsel for the
What's
respondents
the
also.
matter about?
My lord, there was a certain regularization order passed on the basis of which we were required to give him all the salary from around 1997 onwards. But certain documents were forged. The very regularization order was a forged order.
Was the order of the learned single judge.
My lord,
Learned single judge is allowed the.
allowed the writ petition on the basis of those documents and also on the basis that the final report submitted by the police on the basis of which we had alleged the fraud was accepted by the department. Later on, we came to know that that was an impersonation. The matter was reopened by this honorable court and it is now facing trial.
It's for the other side.
I am appearing for Mr. A. Bhattacharya, Lordship. He is the legal aid counsel for the sole respondent.
So do you have any objection,
No, Lordship,
Arjan, after summer vacation?
I'm obliged.
much obliged. Lordship.
Adjournment request from item number 28 to 44.
My pleasure, Lordship. Lordship, I beg to mention item number 41, as my senior Mr. S.K. Mehdi have some personal difficulty. A consent from the other side has been
Arjan,
taken.
after vacation.
Lordship, with regard to item number 44, Lordship, that might come at a Lordship. It may be taken up on Friday next, Lordship. Consent has been obtained.
Consent, I am appearing for the other side, for the petitioners.
Yeah,
Lords, I would be opposing an adjournment only for the reason that on the last occasion when this matter was heard on 2nd of April, we were seeking for a stay and the learned Advocate General was appearing for the stay.
we'll hear at the point of time that they are.
Item number
objecting.
44, Lordship, I am.
Item
So very
number
well.
they are
At the
objecting,
time.
Lordship.
Then at the time we'll hear.
From item number 45 to 54.
May please, Lordship.
Yeah,
Lordship, I beg to mention item number 21 and 22, Lordship.
yeah. Yes,
Lordship, this matter will come up after 2 weeks, Lordship.
await return of notice of respondent number 7 for 2 more weeks. Affidavit on behalf of the- Okay. Same adjournment 2 weeks or after a summer vacation.
Your Lordship, however, on the last order, they were being granted time. And they are keeping on taking time again and again.
Yeah,
Whereas this is from the social welfare social
Social
justice and empowerment side. However, the Assam Police Department is still silent on that part. That what they are doing, we are
Social
still.
Justice Department was supposed to file an affidavit.
Yes, Lordship, Lordship will file it after, let it come after 2 weeks, we'll file it, Lordship.
Okay, let them file the reply.
Your lordship, the problem is, whatever their instructions are, they will be filing. And that is from the Social Justice and Empowerment Department.
Yes.
But what the Assam Police Department is doing, still we are not aware of. Because they are supposed to file or apprise this court regarding their steps.
If they are not going to file, we are not, we can't insist them. We'll pass an order on the
Yes.
basis of if they're not, they'll not file any reply, we'll pass an order on them. Why to insist, if they are not willing to file any reply, what to do then? Yes.
May I please, your lordship? With the consent of other side, I beg to mention item number 48. My senior is out of station, so maybe adjourn the matter for the day and
Adjourn.
maybe listed after vacation.
Yeah, after vacation.
Highly obliged.
May I please, your lordship? Lordship, with the consent of the other side, lordship, I beg to mention item number 45, lordship. I have duly taken the consent from the council for the various lordship. And I have duly submitted the adjournment slip yesterday before the honorable.
Adjourn.
Deeply obliged, lordship. May I pray for another matter, lordship, for lordship of 13 for 2 notice of SARFAESI Act was issued, lordship. Today I have filed an interlocutory application for staying the on Monday next on 11th. I will be vacated from my premises, residential premises, lordship, and on Monday.
SARFAESI matters, we are not supposed to.
Lordship, it is listed on Monday, lordship, item 39 in the daily list, lordship. In that connected matter, I am the respondent, lordship. In that matter, I have filed IA for staying the
Okay,
lordship.
Monday.
Deeply obliged, lordship, deeply.
Wait, please, also. So with the consent of the other side, I beg to mention item number 50 to 54, my lord.
Yeah, what do you want?
This matter may come after 2 weeks, my lord.
Adjourn.
Obliged.
After vacation, adjourn means after vacation.
Wait, please, Lordship. Lordship, I beg to mention a matter of writ appeal along with the IA for listing on Monday, Lordship.
Why? What's the urgency?
Lordship, the writ appeal was filed on 3rd of May 2024, Lordship. And the urgency is that the learned single judge directed the matter to go for arbitration. And we have, Lordship, like some
Petition is not going to happen within up
yes,
to
Lordship,
Monday.
but there was no arbitration clause, Lordship. That's why, Lordship.
Maybe Thursday, Friday, or whatever.
Lordship, on Wednesday, Lordship.
Thursday.
Lordship, the next Monday, Lordship. Next Tuesday, Lordship.
What's the urgency? What I'm saying, arbitration, if the learned single judge is ordered for arbitration, arbitration is not going to be happen within 2-3 days. Consider it. Thursday,
Lordship, next Tuesday, Lordship. Thursday,
Thursday.
Lordship, there's some difficulty on Thursday, Lordship.
What?
There is some difficulty on Thursday, Lordship. Next Tuesday, Lordship.
Then you have it on the next week, another next week.
Yes, Lordship. Next Tuesday, Lordship. Like next week, Tuesday, Lordship.
Next Tuesday.
Yes, Lordship.
25th June.
Yeah, Lordship, on 18th of June, Lordship. 18th of June. 18th, Lordship.
Okay.
Deeply obliged.
Meet his lordship. Lordship, a similar matter like ours is listed on 13/6. So where your lordship wanted that if any similar matter is there, that may be listed on that day only. 13/6. On 13/6.
No. 13/6 matter is going to be listed.
Yes. lordship.
So,
One matter is our also. That is tagged. That has to be tagged with that.
then already.
No. We wanted to tag. We wanted to list it on that day only, lordship. Highly obliged.
May I please, your lordship? I'd like to make a mention for item number 56, 57, and 58 of the daily list. Due to some difficulty, your lordship would like to seek adjournment in the matter. I am for respondent number 5 in item number 56. 57 and 58, we had a petitioner, your lord.
My lord, I am for one of the respondents, that is Punjab National Bank. My lord, a huge public money has been stolen, my lord, by filing this case.
Are you objecting to adjournment?
My lord, hence, Singapore. They are having some personal difficulties. But then can I pray that your lordship can fix a date on 27th, my lord, of this month?
27.
Lordship, there is an interim order in item number 57. May that continue.
Interim order, if any, in any of the matters will remain in currency till next date.
May I please, my lordship? I beg to mention for listing the matter of Guwahati University and another versus Dr. Parinita Chaudhary and others.
It is a old matter or you have filed it,
Its matter is it's not, it's pending matter only.
pending matter?
But I want to,
From, this
on Wednesday, it will be
24th of June,
better,
commencing from 24th of June.
Wednesday.
May it please your lordship, with the consent of the other side, I beg to mention item number 63 and 64, your lordship.
Yeah,
I'm seeking an adjournment in this matter. Can it be on 24/6, your lordship?
after summer vacation.
Then can it be on 22/7, your lordship? 22/7,
Summer vacation, you get the date from the registry. 22/7.
highly obliged. Highly obliged.
Date from the registry.
Any other request?
May I please, your lordship, I beg to mention item number 37, lordship.
Yeah,
The DVI is out of station, lordship.
adjourn.
Adjourn for today, lordship.
Lordship, contempt case is pending before the single bench. So can this matter be fixed on 12th of this
Which
month?
matter?
That Guwahati University and other versus Dr. Parinita Chaudhary. Yes, Lordship, but I'm praying for the fixing the date on 12th.
12th, no. Sorry. Yes,
For orders, item 1 to 19.
May it please, my lord. In terms of the last order, my lord, we've taken steps for service. I just please, my lord.
what happened? Whether the notices have been served or not?
Through Dusty Malas, we have served. They've been served. We've served them through various field offices. Now you've yet to receive the acknowledgement, Malas. I'm praying for some time to file the affidavits, Malas.
Petition.
Await return of notices for 2 more weeks.
Deeply obliged.
Notices of the answered respondent.
Item 20.
May it please, your lordship.
Ask for it then. 20, they already asked for it. 21 and 20.
My lord, my lord, as per the office note dated 3/6/2024, my lord, service on the respondent seems to be awaited, my lord, because we have taken steps upon.
Await return of notice of respondent number 7 for 3 more weeks.
Standing council.
My lord,
Standing council is saying discrepancy.
I'm obliged, my lord.
Item 23.
So this.
Lordship, I appear for the respondents in this matter, Lordships.
Yeah, what do you want?
Lordships, we on the admission hearing, we can argue, Lordships, subject to my learned senior for the appellants. Because it's an appeal under Lordship 35G of the Central Excise Act. And Lordship, the disputes relates to the factual issues whether ours was a new unit or not, as per the notification 20/2007. The Commissioner appeals as well as the Honorable Tribunal has ordered in my favor. Department's appeal has been dismissed altogether. Now they have again come up before your Lordships seeking an intervention under 35G.
There's only one respondent.
Only one respondent, Lordship.
Okay, Mr. So-and-so put in evidence on behalf of the sole respondent. Service is therefore complete. Yes,
May I, Lordship, I am appearing for custom on behalf of SC Cal.
yeah, what do you want?
Lordship, this matter may be fixed for adjournment, admission.
Which date?
Lordship, may I request for 24th of June, subject to your Lordship's convenience.
4th of June. Let's
Date
not
for
adjourn on 24th of June.
Lordship, may I come up with the paper book which we filed before the session, which will help this honorable court if your Lordships give me the permission.
Yeah, you can, whatever the documents we want to rely, please bring.
Grateful, Lordships. Grateful. Lordships.
Item 24.
May I please your lordships? Lordship, service upon respondent number 5 is awaited, lordship.
Since when? It is abated since long, therefore.
Yes, Lordship.
Take fresh steps. Okay.
Interim is
notices-
there, Lordship.
Notices issued to the respondent number 5 has not been served. Till, since long, let fresh notice be issued to the respondent number 5. Requisite to be filed within a period of 1 week. On filing of the same, registered date is so and so. On filing of the same, notices be made returnable 4 weeks thereafter. Interim order, if any, to continue till next day.
Obliged, Lordship.
Item 26.
Unpresent list after summary.
Item 27.
Lordship, please.
In the year 1988, this land was actually given to the Sant House, respondent number 9. Subsequently, the allotment was made. We have been in this property for last 25 years or more. Subsequently, Your Lordship, there was a settlement order that was passed on 5th of August 21. The entire purpose, I'm 16, sorry.
Where was the original legal allotment order?
We have applied for it, but we've never obtained it. We've written letters, they have not given it to us.
So from where,
Even an RTI was filed, your
from
lordships.
where we find
In the Jamabandi, your lordships, at page 66, the orders are reflected. That is the Jamabandi which we have filed at page 66, Annexure 5.
fine.
The orders are reflected there on the right column, your lordships. The first order is 5/8/21 passed by the government. Then there is 10/8 orders passed by the additional district ADC. Then the circle officer on 11/8.
Read.
Yes, those lordships. In accordance with the order dated 5/8/21 passed by the government of Assam by letter dated so and so, as per the order dated 5/8 by the additional deputy commissioner Kamrup, Metropolitan District, and the order dated 11/8 passed by the circle officer, and the land measuring so and so, totaling to 25.42. Has been in favor of the Socio-Economic Development and Cultural Development Organization of Amguri constituency at Rupnagar, Guwahati, on a payment of 61 rupees through Chalan Y dated so and so measuring 13.43 are covered by dark number 378, next page, your lordships, page 67, and 1/1919, leveling revenue of rupees 603 and local tax of rupees 150.97 and land measuring 12 are covered by DUG number 186 of 1920, leveling revenue of rupees 540 and local tax of 135 and the new Patta 984 has been created in the name of the said organization. It has been entered in the record of the Bengali year 1429. It is worth to mention here that as per the government order, the transfer of the said land by way of a sale has been stopped for 15 years. Bipin Das, the Lot Mondal and Samed Ali. As per the reports and facts in the hand of the Jamabandi and the aforementioned corrections have been made on related to 8/9/2021. So this land was actually given for this purpose.
But where is this condition that has been waived now?
Yes, that is page 68.
68.
Yes.
Read.
The last line, your lordship, in compliance. The last line in page 68.
Compliance with the order.
Yes, 16/7 passed by the government of Assam, and as per the order dated 87/2022 passed by the learned additional deputy commissioner, and as per the order dated so and so, the prohibition or order regarding transfer of the land measuring so and so in so and so totaling to list Handar Moza has been revoked, and the order is corrected to that effect.
What is the connection between acre and R? 1 acre is equal to how many R?
I guess.
Land to measure.
What is the acre? 40.46, 40.46, 8564224 is the conversion. 40.46.
40.46 what?
The heirs,
Yes.
yes,
Is equivalent to?
one arc.
One are equivalent to how many bigas?
That we'll have to find out, Your Worship. That I'm not sure. That I'm not sure. One bigger. How many arcs is that? One bigger. It's around 1 acre, 0.613 is the bigha. Approx. Six one three bigha is how much 1 acre is.
Council, please clarify this 25.42 R.
Yes.
Land which was allotted
Yes, Your Worship.
is equivalent to how many bigas?
25.14. 25.14 is equal to how many bigas? 24.14. No, in the first page. This one. 25.14 into how many bigas? Approximately looks to be 1 bigger because that is what is mentioned here also, your lordships. It looks to be.
Looks to me,
I
it's
mean,
different.
I'm not.
Because the thing is,
Yes,
what we find, that total 25.42 RA land was allotted in Kathan, this DUG number 388-1919-1865-1920.
Right,
Okay,
right,
and now whatever they have relaxed
is 1.
is 1919, 1 bigger 3 lesser, and 1920, 4 bigger 9 lesser, and 984.
Yes,
984 is not in the original allotment order. That number 98 or patta number 984. Now 1919 and 1920 they have relaxed, not the whole land.
yes.
So first of all, you please clarify us.
My
how much
instruction is
land
that
was
it's around 2 bighas.
originally allotted. How much
It's-
land was originally allotted, and out of which if a certain portion of land, this prohibition order is revoked, yeah, whole land prohibition order is revoked. That you have to clarify.
Yes, the lordships, may I just apprise your lordships, when in 1988, when the first request was made, the request was for 2 bighas. So the prohibition order,
Ultimately, the land was allotted only in the year 2021, even though
Yes.
there was a request or whatever it may be,
Right.
that was only a request, and ultimately it culminated in allotment
right,
in the year 2020.
21.
Your case is that there was a condition, prohibition of not, they will not allow to sell the land for 15 years.
Right,
Now they have relaxed.
yes,
Relaxed it in respect of whole of the land or part of the land.
whole of the land.
Sir, from where we get it?
Because your lordships, if your lordships comes to page 66, once again, I'm just troubling your lordships once again.
Yes.
This 25.42 is equivalent to around 2 bighas of land. So the entire land was
Sir,
actually being
yeah,
done.
This 25.42 R
Yes,
is equivalent to 2 bighas.
2
of-
bighas.
From where we go?
I'll have to show the calculation, lordships. I don't have it as of now. I don't have it as of now.
Tomorrow?
Uh, I am available tomorrow.
But tomorrow is Saturday.
Monday. Oh, Monday will not be. May I just request for this? Anything? Yes. He's saying, where is it? It says one bigger. Where is it? It says the other one bigger. What is it? The police is one. So that is 19 and 20. 19 and 20. This is.
Yes. We are fixating on the next Tuesday.
Great.
And in the meantime, you may also, and you clarify this, how much
Yes.
land was allotted, and you may also seek a preliminary instructions in the matter. Learned consent for the petitioner takes some time to clarify that how much of the land was allotted to the respondent number 9.
9.
Respondent number 9 by the government-wide allotment order dated 10/8/2021. And the respective orders. Full stop. This on Tuesday,
Well, can it be on Wednesday?
Tuesday. In the meantime, the council for the state may sought preliminary fact-finding report, preliminary instructions from the state.
Item 28.
Extremely great.
before my learned friend submits, your lordship, we'd like to file an objection in this matter, your lordship. The reason being that two documents which have been filed, which were not before the honorable single judge when the impugned order was passed, your lordship.
I'll address your lordship without those documents.
And your lordship, also, the appellant do not fulfill the conditions of order 41 rule 27, your lordship. That also we'd like to highlight. So if an opportunity is granted to file an
I'll
objection,
address
your
without
lordship,
those documents.
we'll file those.
If need be, he may object. I'm moving the matter first time, my lord.
Need not to give any time to them to file objection.
So far as the documents are concerned,
Whatever it may be, at that time you can very well make submission, whether time is to be granted or not.
then I can place the documents by way of an additional affidavit also, my lord. That may be allowed.
It's another thing. We
So
consider
the
these
lordship
objections.
may certainly grant him time.
Maybe if you have already filed, we'll consider these objections. If the documents are worth consideration, we'll consider it. But whether now time is to be granted to him or not.
I leave it to your lordship.
Then consider appearing for the respondent number.
Lordship Corporation Department, your lordship. Respondent number 1, 2 and 3, your lordship.
1, 2, and 3, place some time to file counter to the writ appeal. Time period is granted, list on.
Lordship, after 2 weeks, your lordship.
They're delaying the matter. They are delaying, in other words, if I may put it, subject to correction, my lord.
25th of June.
Subject to correction.
25th of June.
Additionally, I would also place the same very documents by way of additional affidavit. Technical matter.
You are free to do so.
Absolutely. All right, lordship. But could it be sometime later or earlier?
Whatever later, then it will go after summer vacation.
A little bit earlier, my lord.
Little bit earlier, 25th is the
1-2 days earlier. I may not be available.
okay, 26th, 27th.
I'll leave it to your lordship.
uh,
The 25th, post 25th, I may not be available. That's why I was making a request. Something prior to that.
24th.
24th.
Right.
By the way, where are you going?
Puri. Jagannath.
Jagannath.
Lordship.
Item 29.
May please, your lordship. This influence judgment is page 110, your lordship. This by this influence judgment, your lordship, by selection made by this order dated 19/4/2022 was interfered with, your lordship.
Okay. Your name was sent for appointment as the president of the SMC.
Lordship, my application may, to that effect, my application may kindly
Sir,
present.
your name was forwarded or not?
That is the school authority, Lordship, and the inspector of the school.
We are asking this question because
Lordship,
the
so far
learned single judge observed that your name was not even forwarded. And names of two other persons were forwarded for the president and the vice president. And despite that, you have been appointed as president of the SMC.
Lordship, this is on the basis of the contention filed by the respondent number 5.
So
who is
whether
the
you
inside
have filed
principal.
any document of this effect, your name was, you were empaneled and your name was recommended. Is there any proof document?
That documents I do not have because the person Lordship, inside principal who has the filed this affidavit, Lordship.
Either you show us, your name was also there in the panel. Otherwise, what is the point in, even though if we grant you opportunity, you have to satisfy this.
Lordship, may this, Lordship, the person who has filed this affidavit on behalf of respondent number 5, your Lordship.
Do you have any proof that your name was
that is why
empaneled?
I do not have because the school authority, the principal who was in charge, that was already suspended
is
because
clear
of the
that
complaint
you-
lodged by me. And he has already retained all the documents, that is why I lost. And there is no record from the inspector of school that has been produced.
Sir, you satisfy us, your name was empaneled. We'll pass an order in your favor. Satisfy us.
Lordship, that I have to take instruction to that effect, your Lordship, that will fix on Monday, your Lordship.
Counsel for the appellant place for and granted time to submit the proof that his name was also empaneled for appointment as the post of appointment as president of the school management committee of a concerned school, and the same was also forwarded to the competent authority. List on
Monday.
26th of June.
Item 32.
May please, your lordship. Lordship, item number 30, it has been complied with, lordship.
Complied with.
Yes, your lordship. We have been given possession.
And what about 31 and 30?
31, lordship, redate has for physical possession has been issued on 26.
26.
So it may be kept pending until then, and lordship,
There is a need, once they issue, fix the date, we are not going to do that. And in item number 32,
32, lordship, the respondents have obtained a stay in a surface application.
and what remains?
Lordship.
Okay. In view of the fact that the in view of the fact that in the matter relating to the writ petition number 1108/2024, the authorities concerned has already initiated necessary steps for compliance of the order passed by the district commissioner.
Lordship.
District Commissioner, therefore, no further order is required to be passed in this petition. The same is therefore disposed of. Next, the writ petition number 1105/2024. It is informed by the learned counsel for the petitioner that the concerned authorities has already initiated the process for compliance of the order passed by the commissioner, and the next date is fixed as 26th of June 2024. Stop. In view of the above fact, no further order is required to pass in this petition. The same is therefore disposed of. Writ petition number 1159/2024. Then council has submitted that since the respondent, private respondent, since the DRT has already passed and stay orders in favor of the private respondent, the concerned authorities cannot initiate the process for compliance of the order passed by the district commissioner. Full stop. In such circumstances, when the DRT has passed and stay orders in favor of the private respondent, we don't find any case for issuing any direction to the respondents. To the respondents, to the authorities of the state to comply the order passed by the deputy commissioner. Hence, this writ petition is also disposed of.
Obliged.
Item 33.
May it please your lordship, madam. There is a caveat in this matter and they have appeared through the caveat.
Yes, I'm forgiving.
There is a similar matter pending, another matter.
No, madam.
Another appeal was filed, lordship, by us. Another appeal was filed by the lordship.
It will be in the same judgment.
Yes.
By the private respondent of court.
I'm a party on It a fees number one. Number.
Expiry 169.
Which one second.
Hello, I'm just been apprised by my friend that there's another matter filed by the private respondent. So I pray, my lord, that in this case, notices may go and the matter may be tagged along with that item after the reopening of the.
What's the number of that appeal, writ appeal?
169, document number 169
169. 1692
of 24.
24.
Yes, sir. Of course, in that case, already then to take this matter, Lordship.
Issue notice, Mr. So-and-so. Accept notice on behalf of the state, who is appearing?
I am appearing for 1 and 2, my lord. Respondent number 1 and 2.
Mr.
Yes, that's.
How many respondents are there?
Five.
That's what.
What about the respondent, other respondents?
My lord, notice will go. Notice will go to 3 and 5.
3 and 5. Mr. So-and-so is appearing as excavator on behalf of the respondent number 4. Let notices be issued to the remaining respondents. Registered daily and tag this writ appeal along with writ appeal number 169/2024.
Hello, may I pray it after reopening of the vacation? my lord? Next step.
Appeal, we have already fixed the date, so it will be listed along.
They fix it. I don't think, my lord, the date has been fixed like that.
They will fix by the registry and it will tag the date.
We'll make a mention before the date. We'll make a mention before the registry.
Item 34.
May I praise the Lordship? Lordship, this matter pertains to a challenge being made to the rules of the Provincialization Act of 2017. So it may be listed before the special bench constituted.
List before this special bench, list before the special bench which is considering the matter regarding the validity of the provisions of Assam in fact, bracket provincialization of service of teachers and reorganization of educational institutions bracket close Act 2017.
Obliged, sir. Obliged.
Item 35.
Yes, Lordship, I have received instruction from the department, Lordship. I need to bring on record, Lordship.
High Court.
So, Mr. Saikia, you are the petitioner number 2.
Lordship.
Who is appearing for the petitioner number 1?
The
Lordship, petitioner one authorized me to appear on behalf of them.
So you are appearing as a lawyer or as a petitioner in person?
Petitioner in person.
How can you appear a petitioner in person for petitioner number 1 also? He's your friend.
They are the
Friendship treaties cannot be enforced in the.
They are duly authorized me to represent them.
On what capacity?
Chief Secretary authorized me with written documents.
And what is this organization is?
Organization, Your Lordship, this is a registered organization.
What is the registered organization? What is this organization?
Organization is consisting the general class population of Assam.
80% of general class of population of Assam since 1996. What is the authenticity of this, sir?
Lordship, this organization.
How this personally, by the way, how personally you are agreed by this?
I am also general class.
80% of the people of the Assam are being deprived by this enactment of this law. Certainly, out of those 80%, some of the persons are capable to approach this court.
Lordship, actually.
So, who are you? By the way,
I am also belongs to this community.
There 80% citizens of the 80% includes, I think, so many of the persons sitting here also.
It is a general class population. This organization going to this class of population, Lordship. There's a district committee also, each and every district.
Have you filed PILs earlier?
Lordship.
Mr. Counsel, there are the rules regarding this filing of PILs before this court. Have you complied those mandatory conditions?
In affidavit.
Are you aware of about those such rules?
During the filing the affidavit, Lordship, I see, but
there are instructions for filing public general instructions. Well, whether you have followed those instructions or not.
Mr. Saikia, you examine it.
Lordship.
There are High Court PIL rules. Lordship. Go through the rules, more particularly Rule 10.
Lordship.
And see whether.
If the petitioner is an organization, the name and addresses of its offices, beings and nature of its activities shall also be stated. What are their activities? What is this activities of this organization or registered society? Simply you have said that here in registered organization has been represented almost 80% of the general class of the population since 1996 onward. Why is 1996 only?
This
Who is
petitioner
the
is
office bearer of this office bearers names and addresses of office bearers of respondent number 1? And what are their activities till date?
yes, Lordship, they have, but
They have, where is the mention in the PIL, sir? Nikhil and concept of the petitioner prays for and granted time to satisfy this court that the instructions as provided in Rule 10 of the Guwahati High Court Public Interest Litigation Rules 2011 has been followed or not in filing of this PIL petition. When?
after 1 week, Lordship.
After summer vacation.
of last week.
This, we don't want to make any comment on it, but
Lordship.
it's a publicity interest litigation. Seems, yes.
Item 36.
Yeah, please. Item 36, I am for the respondent number 6.
Yeah.
Our affidavit is ready, we are going to file by Monday.
Monday.
By Monday file, we will file.
Nikhil and consent for the respondent number 6. Phrase short time for filing counter affidavit, time period for is granted. List of 21st June.
Item 38.
Your lordship, earlier notice was issued, your lordship, in this matter, your lordship, however, this notification at NHR 1, that is at page 16, your lordship, it is only for 3 months, your lordship. At least I expected the your lordship, they will apprise this honorable court that this practice will not be continued further.
Thank you, I have communicated with the department. I'm still awaiting my instructions.
But this prohibition order was only for the period of 3 months.
3 months.
That is now over. That
Yeah,
period is now already over.
Yes.
Okay. The by way of this petition, the minister is challenging the validity of the order dated 7/3/2024, whereby the Revenue and Disaster Management Registration Department, Government of Assam, directed the authorities concerned not to issue NOC for a period of 3 months in case there is an attempt of fraudulent transfer of land by some religious community to some other religious community. It is clear that the 3 months period is now over. Hence, we are of the view that this PIL petition is has become infectious, dismissed as infectious.
May I please, your lordship, if fresh cause of action, your lordship, I may be allowed.
We are not commenting on that. Fresh of option is there. Certainly, if law permits, we can very well do that. Because for a specific notification, if fresh notification is to be, they file any fresh notification, you have fresh cause of action.
Lordship, oblige.
I'm deeply obliged, Lord.
Item 39.
My lord, in this case, my lord, I have filed an additional affidavit, my lord. That is already on record, my lord.
Additional affidavit for what?
By the appellant, my lord. For bringing some advertisement, my lord, as well as on decision of the honorable court, my lord. Of the similar footing.
Have you filed an affidavit?
My lord, additional evidence has been filed.
Have you filed that affidavit?
Yes, my lord.
So, in that affidavit, you have clarified that,
Yes.
the, requisite qualification was not, higher secondary science.
Yes, my lord. There is
On
some
1/4.
some advertisement I have annexed, my lord. Some earlier advertisement, my lord. There was a collection for SSLC only, my lord. And subsequently one 2019 advertisement, my lord.
On that day, we ask you, bring the rules. In the year 2015, those rules which were in, force.
My lord. The advertisement, my lord.
Pursuant to the order dated 1/4/2024, he has already filed. In terms of the order dated 1/4/2024, he has already filed additional affidavit. The same is not available on report office to check and place the same. And list this matter on 19th of June.
Smile. Obliged. Item 40.
Lordship, in this case, I pray for a week's time to file an counter to the affidavit in reply that, affidavit in opposition that has been filed. Because they are from,
They clarified.
they have clarified, they are saying that it is not within the FIR, but while doing so, they are taking into account that my plot of land only.
On consent for the petitioner pays for and granted time to file counter to the response filed on behalf of the state government, list after summarization.
Appellant, huh?
Appellant.
Item 42 and 43.
My lord. My lord, by order dated 4/4/24, my lord, the respondent NC Hills were directed to furnish the details of beneficiaries and the mood and basis of making payment. So far in their affidavit, my lord.
I'm going to do some inquiry to our former district heads. They can make it. Yeah. This is. What now is the problem? This is.
Yeah.
So the mood and basis of doing it, that has not been, my lord, furnished before this honorable court. Whether, my lord, on that occasion, the submission was made from the NC Hills that they have adopted a new, my lord, mechanism that is direct purchase. So direct purchase of land, my lord, has to be followed by some law, my lord, like settlement made with the affected persons, my lord. There is nothing to show from their affidavit, my lord, except this annexure 2, my lord, list of beneficiaries. That is also not certified also, my lord. So the mood and basis is, my lord, is very much, my lord, they have done something, my
In
lord.
this matter, Mr. Aram Das will do the case, Lordship. I'm seeking an adjournment today. He is out of station, Lordship.
You're junior to him.
Yes, Lordship.
You're associated with Mr. Das.
Yes, Lordship.
My lord, only thing is that, my lord, in my additional affidavit, my lord, at page 224, my lord, paragraph 4, my lord. Page 224, paragraph 4, my lord. Since they are, my lord, seeking adjournment.
On the last occasion, Mr. Na, so the NCL has submitted this file an additional affidavit. Wherein they have annexed a list of the persons to whom the compensation has been granted.
Yes.
But they have filed a counter, and it's very, I mean to say, it's strange that the compensation was granted in the name of NCL.
Yes, that is it.
But amount has been, PWD has given the amount to the NCLs, the revenue.
But NCL is distributing compensation to itself.
No, to the beneficiary. They have to.
It is, they have specifically said in additional affidavit.
But what?
You asked Mr. Das, we are going to pass an order for holding an inquiry by a retired judge, or maybe because it seems the compensation to the rightful persons have not been distributed.
Well, more than 20 crores they have taken.
Mr. So-and-so,
Well,
appearing
one
for
thing-
Mr.
one
Das
thing- one
for
more thing,
NCL's concept. Raise short time, place for an adjournment, as Mr. Das is not available today. List on it, which date? List on 20th of June. 20th of June.
Item 44.
Back to appear. But in item 44, we have, yesterday we have made a request for, in fact, we have taken
They
consent.
are objecting to it.
We have taken consent, they agree.
But
Because of some
the
difficulty
concept
on our part,
appearing through video conferencing.
Yes,
is
yes, I'm
opposing it.
But I have to reiterate my prayer, Lord. I have some difficulty today, Lord. My Lordship, kindly fix it on Friday next, Lord. Kindly pick it up on Friday next.
Yes, madam.
My lords, I have only two concerns which I just put it before the Honorable Court to consider. This matter was first listed on 2nd of April, my lords, and this notice.
Madam, please try to understand on various occasions on your part, adjournment has been sought.
Once, my lords.
Not once, twice or thrice. Madam.
My lords, I'll stand corrected once only, but
Very much aware of this
I'll-
order.
I place why I'm lords today insisting for some order, my lords, only two concerns. I just place it before the court, and the Honorable Court may kindly consider. My lords, one is
Without hearing the other party.
Lord, they are there before my lords. I'm only requesting for notices.
In fact, learned Advocate General appearing in this matter, and today.
Just allow me to complete the submission. My lords may feel appropriate pass an order on that regard. On 2nd April, when this matter was listed, my lords felt it appropriate to issue notice only to state of Assam.
Yes.
If my lords may kindly see page number 8 onwards, 7 onwards, we have 7 respondents therein.
Yes.
Now, state of Assam, lords, after notice had filed their counter on 20th of April.
Yes.
And in my respective submission, that is very sketchy counter. It does not address the concern, and the matter is quite serious, my lords.
Yes.
In my humble submission, I would request my lords to please issue notice to respondent number 2. Respondent number 1 is Ministry of Culture, respondent number 2, and precisely for respondent number 3, and my lords, respondent number 7. Because they apparently have understood the case as if we are saying, please do not cause any change to the building. That is not the petition at all. The petition was that the goddess there in Das Mahavidyas and the Maa Kamakhya temple are the natural springs. And any kind of digging, any kind of construction work may cause a serious damage to the flow of the water. That is completely vanishing the goddess itself.
That is, that response is actually is to be filed by the state government because the.
No,
ultimate
man, I'm so
state
sorry.
government is going to execute the, whatever the renovation or whatever they are planning.
Lords,
That is to be executed by the state government.
Lord, the state government's response has come, and they apparently have understood the case as if we are talking the buildings only. Now the concerned bodies are, my lords, the Ministry of Culture as well as the Archaeological Survey. And therefore, I am beseeching this honorable court, let the appropriate reply come from them.
Certainly, we are conscious of your request, but let the Advocate General may come on the next date and he'll apply. Then we'll consider if we notice is required to be filed to the other respondents. Certainly,
Lords, in the meanwhile, since
when Mr. Advocate General is available,
Lordship may kindly keep it on next Friday.
next Friday,
Next Friday. Lordship.
then we are listing it on 24th of June.
On 14th, Lordship may keep it.
14th, my lords may have it. They are requesting for 14th, and my lord, that is 1 week from today.
Yes, yes.
My only concern is they are proceeding with the construction.
14th, we may have some difficulty.
Let's only make an oral observation to them. On 2nd of April, the learned Advocate General said we are not proceeding with the construction work.
No, this was not the statement.
They said this is the preliminary stage.
Madam, please try to understand. They simply said that we are not going to disturb whatever the that sanctity of that place is. That was the statement. They have not said that we are not.
I must have in that case, my lords, misunderstood the very simple sentence made by them. But I am lords, what I understood, they said we are at the preliminary stage. It is difficult to reach to the stage of construction.
What we feel.
My concern is
we are not. What we feel that on that day the statement was that we are. The statement was not of this effect that we are not going to. We are not initiating the construction process. They said we are not going to disturb that. Whatever it may be, we'll hear you on the next day.
My lords may only observe that no digging should be done. My only concern is no digging should be commenced, my lords.
21st of June.
My lords, I'm still not making a submission. They may proceed with whatever they want to do, proceed with the preliminary works. No digging shall be done, lords, before the next date, because digging would cause, my lords, damage.
Yes, but we will consider this request on 24th.
21st.
21st of June.
21st of June. Very good.
For hearing, item 46.
My lord, the matter relates to recruitment of a grade 4 in the District Legal Services Authority, Kamrup. Now, if your lordship would kindly come to page 43 is the advertisement. Applications are invited from Indian citizen for filling up the following temporary vacant posts in the office of the District Legal Services Authority, Kamrup. We are concerned with serial number 2, peon. Now, please come to my lord B, 2B. This is what requires interpretation in this case. For the post of peon, class 8 standard pass, preference will be given to those candidates who have already worked or working temporarily as contractual fixed pay basis in subordinate judicial court / office. Then, my lord, there is an interview component, and the selection was made entirely on the basis of interview. If your lordship will kindly come to page number 87. Now, this is the affidavit which was filed by the Legal Services Authority before the learned single judge at page 87, para 6. That in reply to the statements made in paragraph 6 of the petition, it is stated that in order to fill up one vacant post of LDA and one vacant post of peon in the office of the District Legal Services Authority, Kamrup, Guwahati, a selection board was constituted with 5 members on 19/1/2016. In the meeting of the selection board held on 29/2/2016, it was resolved to advertise the vacant post of 1 LDA and 1 peon, and to advertise in 2 widely circulated dailies, that is 1 English and 1 Assamese. An advertisement is dated, my lord, 8/6/2016. Now, this is important. It was further resolved to give special weightage to candidates with similar experience in subordinate judiciary. It was also resolved that for the post of peon, the candidate would have to appear only in viva voce test. So, my lord, if we read clause 2B of the advertisement, read with para 6 of the affidavit filed by the appointing authority, that's the selection board. Now, what clearly transpires is that a conscious decision was taken that special weightage will be given to candidate who has experience of working in subordinate judiciary. Now, therefore, my lord, this decision must be reflected in the decision-making process. Now, in the instant case, my lord, this is not evident. That is our challenge. Now, as a result of this selection, your lordship should kindly come to page 61. Lord, page 61, select list for the post of peon in the office of the District Legal Services Authority, Kamrup. Mrinal Kumar Nath, that is respondent number 4, who has been given first nomination. And waiting list number 1 is the appellant, writ petitioner appellant. Then, my lords, after the selection was made, we assailed the decision, and an interim order was passed by the learned single judge, which your lordships will get at page 71. And the operative portion is at page 73. any appointment made will be subject to the outcome of the writ petition. This was on 17/2. And on 27/2/27 at page 74, the respondent number 4 was appointed. Mrinal Kumar Nath, so-and-so is hereby appointed as peon grade 4 in the establishment of the District Legal Services Authority in the so-and-so scale of pay. ठीक है, काम कर रहा था ना?
So this respondent, the appellant was working on contractual basis with,
For 2 years,
with
same office,
which office?
same office.
Same office?
Yes.
And this respondent number 4?
No, he had no experience.
He was not at all working?
No.
Not at all working?
No, he's in the IA file before the learned single judge for vacation of that order, my lord. They said that they worked in a particular college, but no particulars were furnished.
Particular college means?
In some educational institution, he worked. My lord, normally the word preference has a definite legal connotation. That is, other things being equal, then if there is experience, then that will come into play. But having regard to the specific stand in the affidavit, where it said, my lord, that special weightage will be given to an applicant who has the experience of working in judicial establishment.
But was it mentioned in the advertisement that special weightage will be given?
No.
Then even if they write in affidavit, they can't give it.
No, question is, but then it says it will get preference. How, in what manner preference has been given?
As you rightly mentioned, the expression preference in these matters has been interpreted in countless judicial pronouncements. Other things being equal, preference will go to the candidate who fulfills that norm.
Yes.
But here the appellant has scored 33 and the private respondent 37.
37.
So in terms of marks, he is better in order of merit.
No, but the difference is in the experience column. Please come to 101.
So is it the case that there is no experience of the private?
Exactly.
Has it been
Exactly. No, the records must reveal what experience was taken note of. The records of selection must reveal that what was the.
Sir, experience of work can be gained by a person in working at many organizations,
No,
not
my lord,
in particularly
I
judicial office.
agree.
Also, the experience can be gained even by working in the household.
Of course, I'm not saying no to it, but my humble submission is you come up with a specific stand in the affidavit that your meeting was held in February 2016 and your advertisement is of June, where you came up with the decision that you will give preference to those persons who has got experience of working in weightage, not experience. Now, can they result from that stand, my lord? This selection committee minus must reflect. Okay, experience is okay, but why that special weightage will not be given? So therefore, harmoniously, when we read clause 2B of the advertisement, read with this stand in the affidavit, then the answer is very simple. They must disclose. Kindly come to page number 101 for a moment.
And experience में तो both of you got the equal marks.
My lord.
Experience in the head of experience, both of you got the equal marks.
My
7-7.
lord, my submission is that I worked in a judicial institution for which I'm entitled to special weightage. Where is that? Well, can we discount that stand of the appointing authority?
Mr. Chaudhary, is the expression weightage given in the advertisement?
No.
They explained it.
No, my lord, the advertisement, my lord, what is the content of the advertisement? It was best known to the appointing authority, and it is the appointing authority who has filed the affidavit. Where otherwise, my lord, I have no case. But for the special weightage which I am entitled to as per their affidavit, I have no case. Because lordship will not sit in appeal over the marks given by experts. We are conscious of that. But lordship will have to give some meaning to the affidavit which they have filed. Kindly come to that affidavit for a moment. But for this, I don't have a case. Please come to page 87 for a moment. In the meeting of the selection board held on 29/16, it was resolved to advertise the vacant post, etc., etc., etc. It was further resolved to give special weightage to candidates with similar experience in subordinate judiciary. It was also resolved that for the post of peon, candidate would have to appear in viva voce only. So, my lord, where is this special weightage? Let the matter be remanded back to the selection authority.
The copy of the resolution?
My lord.
Copy of the
No, that they will be having, my lord. This is their affidavit.
Yeah.
Is their affidavit.
Yes.
But for this paragraph in the affidavit, I don't have a case.
Do you have the record? Resolution?
I'm appearing for the respondent number 4. Through RTI, I have got these resolutions with me. So if your lordship will come to that affidavit of mine,
Fine.
filed by the respondent number 4 on 25/3/2022.
29/3.
25/3/2022. Affidavit of respondent number 4.
Page 22.
Mrinal Kumar Nath.
ইয়াততো তোমাৰ বস্তুটো নাই নাই ইয়াত কৈছো ন ইয়াতে এইটো নাই মোৰতো নাই এইটো তাহাঁতৰ মোৰ কথা তুমি ৰিফ্লেক্ট কৰা কি স্পেচিয়েল এক মাস দিয়া 2 দিয়া 3 দিয়া 4 দিয়া সিঙ্গেল জায়গাতে বিনা পয়সায় ঠিক আছে একদিন একটা মাছ দিয়ে মানে আমাকে নিচে লাই দেখিলে দুবছর কাম করলে তাৰপিছত নাই ঘৰ বহি
Page number 7 of advertisement. Yeah, advertisement is there. Yeah. What do you want to point out?
Lordship, no, there is a resolution in the resolution.
But in the advertisement, no such mention was there. That's what.
May I just add to that? When the selection board was constituted, they formulated a modality as to how the marks will be given. That minute I was trying to present before Lordship at page 23. When that in that particular modality of marks, nothing of weightage was been recorded.
So Mr. Chaudhary has made it very clear. His only case is on para 6 of the affidavit. The question is.
Para 6 is not supported.
No, that's his case. We are not going beyond that.
Yes.
Only issue is merely because the affidavit mentions that weightage will be given in the absence of any such criteria mentioned in the advertisement. Whether one of the candidates can. My response would be, it is the appointing authority voluntarily said that. So they understood the advertisement in that particular light. Correct. But the advertisement did not mention it. Yes. So if they include any undisclosed criteria, it will be a assessment made on hidden criteria. That's the law as we understand.
Criteria is at page 11 of
Page 11, you don't have any pagination in this.
yes, find the pagination.
Only thing is, my lord, this decision was taken even prior to the issuance of the advertisement. We have seen that. Yes. There is a decision to give weightage. Yes. But that is not reflected in the advertisement. So question is whether so therefore my humble submission is this matter should go back to the selection committee and they should reflect. That's I'm not saying dislodge this fellow. Matter should go back ideally because it is the selection authority, the appointing authority who knows what are the criteria and they have reflected in the affidavit. The statement made on oath. So even if it is not mentioned in the advertisement, that criteria has to follow. No, question is, well, at times, advertisement does not contain all the criteria. Supreme Court has also said, if a rule prescribes particular criteria and advertisement contains something else, then the advertisement would be bad. So yes, one thing might arise, whether this criteria was gazette notified for information, all that could arise. But otherwise, this was a aspect which was taken note of by the appointing authority. And therefore, my humble submission is record of that selection was বেলেগত কাম কৰাই সেইটো মই কোৱা নাই মই কৈছো তুমি এই এছপেক্টটো ৰিফ্লেক্ট কৰা My lord, it's a tough call. I do appreciate. But then, my lord, some meaning has to be given to the stand in the affidavit. At the end of the day, my lord, we are all doing this job. Even my friend, it's very hard, my lord. I know it's a very.
May I submit something? There is no rules otherwise regulating this selection process. What was in public domain was the final advertisement. We acted based on the advertisement. My appointment is based on the advertisement. The minutes, which was ultimately formulated by the selection board, giving the marks criteria, did not brought in this aspect or element of weightage. Based on that, universally, everyone was evaluated, and I was found to be selected because I scored more than him. So today, to dislodge me, 2017 appointee, on a aspect that was probably taken in note at that point of time, but didn't meet the day of the light. So I think it will be a very hard call.
Judgment reserved.
Oblige your lordship.
Mr. Chaudhary, with the leave of my lord, the Honorable Chief Justice, just sharing a personal thought. When we look into these problems, particularly people in the lower economic strata of the society, how often as judges we feel that perhaps we could have given something to both sides, but the system and our call of duty
Hands are
wouldn't
tied.
permit. That's where the matter ends.
We do appreciate.
That's why it's a matter of debate whether judges and judiciary can ever be treated as a service providing industry. Because a service providing industry must make both sides happy. But every day we are making one side unhappy at least. This is a food for thought someday,
Right.
perhaps. You
It's
can
a-
hardly,
And more particularly for a constitutional court.
absolutely. We are passing orders, one party is dissatisfied. But the fundamental norm of a service industry is everybody should be happy. Which is that litigant who will be happy despite getting a adverse order?
When Chief Justice Sudhanshu Dhulia was there, one day his lordship uttered, आपका बात तो हम मान लेंगे, ये तो बेचारा मर जाएगा. Myself and CC Dutta were there in a particular case. He was telling me, आपका बात तो हम मान सकते हैं, मगर ये तो बेचारा मर जाएगा. So it boils down to that.
Same thing is here.
Oblige.
Item 47.
Oh. Kun? May it please your lordship. My lord, the matter relates to basically we are praying for regularization. My lord. There is a organization under the central government in Silchar, my lord. They're doing some they're discharging their functions in the sphere of automobile testing. So we were all appointed between 2009 and 10 on ad hoc basis, and we are continuing. And we are praying for a, my lord, direction in terms of Uma Devi. At least one time measure should be taken for our regularization. In fact, central government's own circular professes that, which they have not done. That is our case in a nutshell. Now, if your lordship would kindly come to there was an advertisement, then we were appointed. Now we are continued. Page 23 is the advertisement. NETRIP Implementation Society, an autonomous body under the Ministry of Heavy Industry and Public Enterprise, requires the following position on contractual basis with the following background. We are concerned with 2 millards. Mechanical engineer B with 5 to 7 years experience or with a diploma having
Chaudhary,
said
you're reading from which page?
page 23, advertisement.
Yes.
NETRIP Implementation Society and Autonomous Body under the Ministry of Heavy Industry and Public Enterprise, Government of India, requires the following position on contractual basis with the following background. B, we are concerned with 2. BE with 5-7 years experience or with diploma having 7-8 years experience in installation of HVAC, water supply work, firefighting, prevention system, compressor, lift, etc., etc. So pursuant that there are similar advertisements where there at page 42 also, 24. Then my lords will kindly come to page number 25. Now this was the appointment order. January 3rd, 2009. In terms of headquarter office letter dated so-and-so, he was appointed as executive assistant at NETRIP project office at Silchar on contractual basis for a period of 1 year. You had joined duty at Silchar on 15th of October 2007 while he was at probation. Based on complaint and allegation of so-and-so, you were terminated with effect from so-and-so. Now, based on your prayer and submission of your medical report from the principal and chief superintendent Silchar Medical College to the effect that standing medical board had certified you free from substance abuse and physically fit to serve normal, the competent authority has reviewed the circumstances leading to your removal and decided to reappoint you afresh without any employee's benefit for the previous spell of your engagement. Further, since you have now qualified finally in the diploma course in civil engineering along with which you were pursuing at the time of your initial appointment at executive assistant in NETRIP's office, the competent authority on consideration has decided to appoint you as site engineer, the revised terms and conditions. So basically he was on probation initially. Similarly, my lord, page 27 is the another appointment order. Then page 29 is another order. Similarly, 31. So these are the appointment orders up to page number 43.
Yes.
Yes. Then, my lords, we prayed for regularization, which was turned down by the learned single judge. That before I go to other aspects, let me place 2 paragraphs from the impugned judgment at page 109. Page 109.
Yes.
Heard Mr. So-and-so learned counsel for the petitioner who submits that petitioners were appointed during 2009-11 on contractual basis at Silchar pursuant to valid selection process should be regularized. On perusing the writ petition, petitioner's counsel has not been able to show under what scheme or rule the service of the petitioners who are contract employees can be regularized. Further, in case of Umadevi, the apex court held that recruitment should not be made dehors the rules and regularization cannot be a mode of recruitment. The above being said, an exception has been provided by the apex code in Umadevi, which has been clarified by the apex code in ML Keshri for regularization as a one-time measure. A reading of para 53 and ML Keshri shows that as one-time measure, only those persons who have been in service in substantive period for 10 years on the date of judgment was rendered on can be considered for regularization. In the present case, petitioners have been appointed on contract basis in the year 2009-12 And as such, petitioner's case do not come within the exceptions provided for regularization as enumerated in para 53 of the Umadevi. For the following reasons, the petitioner's prayer for regularization cannot be considered. So, my lord, summarily, the petition was dismissed on the ground that we do not come within the purview of para 53. But actually, central government's own circulars are there. Please come to page number 89. These were not taken note of. Yes. This is dated
76.
24, yes. Permanent department. In all permanent department other than the post and telegraph department, the administrative ministries department may, if they are satisfied that the temporary posts are required for work of a permanent nature, convert with the approval of the respective internal financial advisors 90% of such posts up to the level of deputy secretaries, including cast for posts into permanent ones, provided they have been in existence for continuous period of not less than 3 years. Then my lord will kindly come to page 94. This is of 2016. It's in continuation of that 76 circular. Keeping in view the conceptual changes in the field of creation of posts occurred over this period, it has been decided to review existing temporary posts up to deputy secretary level in the ministry department and allow their conversion into permanent ones as a one-time measure. So this is in tune with Umadevi. Then my lords will kindly come to page number 97. Undersigned is directed to refer to Ministry of Finance, OM dated 19/12/16, the one I read, on the subject mentioned above, and to say that keeping in view to conceptual change in the field of creation of posts occurred over this period, Department of Expenditure has decided to review existing temporary posts up to deputy secretary level in the ministry department and allow conversion into permanent ones as a one-time measure. My lord, Umadevi is often misunderstood by many milords, including the honorable courts. Now, Umadevi is not a fetter on the power of the executive to either create a scheme for regularization. On the contrary, Umadevi is a fetter on the power of the constitutional courts like High Court, that normally no order for regularization should be issued. But executive powers has not been taken away. In fact, this was explained by Honorable Chief Justice Chandrasud in that Jammu and Kashmir case, where it clearly says. Now, question is, on the face of this 3 OM, which I have read, which provides as a one-time measure, the learned single judge view is apparently wrong. The learned single judge, I am not praying for a direction.
These instructions are there or some guidelines are there.
No, these are the instructions, my lord.
These are
In
the
fact,
instructions. And
in
on
fact,
the basis of those instructions, whether that exercise is being carried out or not.
no, that is our case. We say we are entitled to a direction in terms of this. Please come to page 86, my lord. For a moment, we are not asking this honorable court to issue a direction. Page 86.
Mr. Chaudhary.
Yes.
For a moment, let us keep the learned single judge's order aside. It may or may not be on the prints of the order. It may be justified, viewed from purely a very narrow angle of Uma Devi. But there is a larger question here. And if you can satisfy us on that, probably the court can go into it. See, your clients were on contractual appointment, correct? They were not holding sanctioned vacant posts.
No, they were holding sanction posts. Only thing is my lord will kindly see, there is a difference. Contractual appointment is made to a post. A post. It is not contractual appointment or a temporary ad hoc appointment is never made to a cadre or a service. It is always made to a post. Now, our claim is to a particular post in that cadre because there is an office where this cadre exists.
No, that's maybe, the question is something different. Your clients were engaged on contractual basis. That would obviously mean that there was a contract of service. That contract would have its own terms and conditions. And obviously, we don't know what is the contract, but there will be a clause, a determining clause in the contract as well. Now, when we have people who are engaged on ad hoc basis or temporary basis against permanent sanction vacancies, they are allowed to draw the pay scale of that vacancy of that post, and they continue serving for long years. And that engagement is on the basis of some process which is in consonance with Article 14 and 16. Then in that case, regardless of all the restrictions coming from the judgments of the Supreme Court, there may still be some scope for the court to examine the matter on the touchstone of peculiar facts. But what we want to say is that once you are in a contractual appointment, that track is completely different. Contractual appointment will not cover, Uma Devi doesn't cover.
Recently, Supreme Court has said in a
Where is that judgment?
Yes.
No, are you, Mr. Chaudhary, we hope you are understanding
Yes.
the contractual means your track is different. You are not engaged in a permanent vacancy which is sanctioned post.
Lord, in this country where there is surging unemployment, this person who are seeking employment, do they have any bargaining power? When it comes to the nature of the post, that is what has been taken note of by the Supreme Court.
That is another matter.
Yes.
We have to pass orders in consonance with settled legal principles.
No, my lord, otherwise also my humble submission would be, but please allow me to read page 86.
Why don't you, this could be an area where there is scope to enunciate the law.
Yes,
maybe.
yes.
Why don't you address the issue? Because problem of unemployment, etc.
No,
these are all different matters.
That's a political problem.
That's a political
not for judiciary. Yes, that I appreciate. Please come to page 86 for a moment. Why you have come before this honorable court? Page 86.
Yes. Yes.
This is in reference to attached OM dated so and so, so and so, so and so of Department of Revenue, where instructions to all attached office subordinate offices, autonomous organizations, societies regarding conversion of existing temporary posts into permanent ones as a one-time measure. There are 13 number of contractual employees working at Naimit Silchar and are engaged in various ongoing projects, activities for last 6 to 8 years. The details of those 13 contractual employees mentioning their date of joining along with respective area of function as per DPR and designation is enclosed herewith as Annexure 3. The prayer for regularization of those 13 employees was placed earlier, but none of them have been regularized till date. Now the undersigned is placing the request as in the subject heading again before the competent authority to consider the case for conversion of those contractual employees to the permanent ones. So we are asking for something which is
done. Contractual employees cannot be regularized. If you can show us an authority.
Yes.
Because their appointment is on a completely different track.
Would your lordship? No, my lord. Yes, I'll come with.
We
But there are
just a minute.
This, any, network is still in existence?
Yes, yes, yes. It has been merged with another body, but it is in existence.
It has been dissolved.
No, my lord, that's the wrong information.
It is by
Yes.
the- it is by the.
No,
this
I know.
Deputy Director,
No, I'm coming to it, my lord.
Deputy additional affidavit has filed,
Oh, no, we have filed a reply.
17 January.
Yes.
22.
They can put it there. My lords will kindly come to page 147 running, where we have refuted this. Page 146, it's a letter by Secretary to the Government of India, Minister of Heavy Industries, 11th of March 22. My lords will kindly come to page 147, para 5.
Yeah.
The two autonomous societies, NETRIP Implementation Society and National Automotive Board, held its governing council and annual general meeting on 9/2/22, and inter alia, among other items, approved amalgamation of NETIS and NAB under provisions of Section 12 of the Societies Registration Act. Then my lords will kindly come to their.
Mr. Chaudhary, persons engaged on contractual basis for a term which is determinable in nature based on a contract, they cannot be regularized against vacant sanctioned posts merely because they have worked as contractual employees for some time, because such a recourse would be in utter violation of Articles 14 and 16. Would you like to address the court on that? If you want to, maybe subject to what my lord may say. Otherwise, difficult.
No, my lord, Supreme Court in one of the judgment has said that these are all alternative method of recruitment. These are not illegal appointments. These are not backdoor appointments. Be it contractual, be it ad hoc. My lord, they require the manpower. But to pay less salary, they are adopting all these methods.
No, ad hoc is different.
No.
Ad hoc
These are all sanctioned posts. There is no difficulty in appreciating. Otherwise, how come they are paying us? Only thing is, my lord, if they.
Under the project.
My lord.
Under the project.
And that project is going on. At least let our appointment be co-terminus with the project.
They are the post against which you have been appointed, sir.
No. Lord, there is a distinction in my humble submission.
Yeah.
We are persons seeking employment. We are all educated, unemployed youth. Ideally, we would like to join a job which has got security of tenure. But that is not forthcoming. Now, consistent with Article 14, advertisement is made. People apply, people join the job. Now the nomenclature is ad hoc, temporary, or contractual. Now the issue is, the moment we join the job and continue for some time, and the further continuance is in the offing, why can't I pray for my lord, either at least equal pay for equal work or some sort of security of tenure? Well, at the end of the day, had I been an appointee who has come by backdoor, then my claim may not be maintainable. Even my lord, Uma Devi also, para 53, we qualify. may not be on the date of the judgment 10 years, but in the Amarendra Mahapatra's case, Supreme Court says 10 years also. Now that has been diluted in Nihal Singh's case, in so many cases. Now, what option do you have? Can we say, sorry, you are not giving us protection of Article 311(2), will not join. What do we do? So the government is taking advantage. That's why Supreme Court has said, please have a look at the judgment. Put the judgment. But let us not understand, Uma Devi in a manner that it takes away the executive right. All that we are saying is there are circulars of Government of India which says to convert this temporary post into permanent. Let them consider why they are not doing. I'm not asking for anything else. Our case hinges on page 86 on the auction judgment. Vinod Kumar. If your lordship wants, I can address your lordships in detail on this point. Please have a look at this judgment for a moment. Yes. Para 4. Yeah. The appellants have approached this court arguing that High Court erred in judgment by failing to recognize the substantive nature of their duties, which align with regular employment rather than the temporary or scheme-based role they were originally appointed for. My lord, if we try to give a meaning to this sentence, so my lord, what is of essence is the substantive nature of the duties, not the nomenclature under which I am appointed. It's a case where, my lord, a direction was issued for, of course, here it was a case of 25 years. Further, their promotion by regularly constituted DPC, the selection process they underwent, and continuous nature of their service for over a quarter of a century underscored their argument for regularization, and that the High Court has incorrectly applied the principles from the case of Uma Devi to their situation. Now, my lord, there is one judgment where the Honorable Supreme Court has said that these are all alternative mode of recruitment. 2015 condition. 2015, 17 FCC 789.
So they have terminated your service.
No. We continue.
You will be satisfied if an order is passed that they will not be replaced.
By another
As long
set
as
of.
as long as
No, my prayer would be, my lord, in terms of that page 86 resolution, our case should be considered. There's an existing OM of the Government of India. I'm not asking for anything else. Let them consider our case. Let them pass a speaking order. And in other parts of the country, in Chennai, they have already regularized similar employees.
Earlier representation is still pending.
Yes, and this has also not been acted upon. On the contrary, they came up with a wrong affidavit that this organization itself has been resolved. On the contrary, now I find, my lord, is amalgamated with another. And there is no financial constraint also. In our additional affidavit, we have brought out that. My lords, if I can just point out page 151.
Just
Page 151.
just
Yes.
So, Mr. Chaudhary, without commenting on the learned single judge's views and findings, we can say that that decision is on the context of the prayer made in the petition and the decision of Umadevi, but taking note of the fact that the petitioners have been working since and purely considering it as a human problem, we can ask the authorities to take a decision on your representation.
Yes.
In the light of.
In fact, this prayer was not there before the learned single judge. The learned single judge in your writ petition, you have simply date for regularization, not even consideration of our representation or for.
Actually, our
It was not
basis
the
of the
case
writ
there.
petition was that resolution.
Sir,
Yes, on the basis of that, we are seeking regularization.
prayer.
Prayer.
Only regularization and nothing else. So I mean, we can't find any fault with the judgment of the learned single judge. You may argue or you may have argued or not. Don't know.
No, it was on the very first day, motion. No affidavit, nothing was said. Very motion they were. No, our only case is, it's not that, seeking something else. We say there are OM issued by the government of India, which permits conversion from temporary or ad hoc to permanent. Now we are praying for that only. And our office has also recommended the case. So that they have not done it.
Yes, Mr. Gupta.
First of all, my lord, if you see, my lord, the advertisement, my lord, the advertisement clearly.
consider their application and pass an order, whatever you
In
think.
terms of Uma Devi,
Sir, Uma Devi, we are not directing any regular,
directing
for regularization, we are
consider-
simply directing, consider it.
will
In
dispose.
terms of the government of India OMs.
That's all.
You will decide by recent order, speaking order.
Close for order. Close for orders.
Item 55.
Sir, Mr. KL, some request was made in other cases that he is not available.
Lordship. Yes, sir, my lord, lastly, this honorable court was pleased to ask me to bring the honorable court, this judgment of this single bench of Honorable Justice Suman Syam. That order, the with regard to financial benefits, my lord. But here, I have seen this order, my lord, this judgment where where it has been said that the person's was aged about 53 years. That is why reinstatement could not be done and financial this benefit was given to the person. But here in my in my case, my lord, the writ petitioner is only 40 years. 40 years old. today.
Since Mr. Kyle is not there next week.
No, since
There was a request on his behalf in the morning that he is not available today in some of the other cases.
I have not been informed, my lord.
Yeah, so he is.
I was sitting all along here, my lord. I was not been informed.
Next week.
Lordship will take the matter.
Mr. Kyle could be busy in some other very important.
No, nowadays Kyle is not there, my lord. Nowadays the Beach Chakraborty is there. Beach Chakraborty. Kyle is
But
no longer.
Mr. Kyle is appearing.
His name has been appeared in earlier occasion. He was the additional solicitor general.
That is.
Deputy solicitor.
Mr. B. Chakraborty is now appearing in
Yes,
this matter.
yes.
But his name is not there. Again, he'll say, my name is not there. Showing list after a week while showing name of Mr. B. Chakraborty as counsel for the appellant.
Yes. Can I show this lordship's order, my lord, the single bench order?
Item 59 to 60.
My lord, the matter relates to a recruitment of constables to Sibsagar district. Now, this advertisement is of 2009. Advertisement is of 2009. And the writ petition was filed challenging, on the ground that there are lot of illegalities in the selection process. Now, the learned single judge, by judgment delivered on in 2019, came to a conclusion that lot of irregularities are there in the selection process. However, since more than 8 years have passed since the appointment, the learned single judge did not interfere with this selection. However, learned single judge made 3 observations, which your lordships will find at page number. Two, my lords. Page two, one second. Page number 222.
That's inside, okay.
As a matter, yes, 222, yes. Before that, if your lordship would kindly come to page 221 towards the bottom. Para 13. The next question which now requires to be considered is what relief that can be granted to the petitioners. As already noticed, petitioners have not implicated those persons who according to them have been illegally and arbitrarily selected. Admittedly, the selected candidates were appointed after filing of the writ petition, but the petitioners have not implicated the appointed candidates and have also not obtained any interim order from this court. In such circumstances, it will not be fair to dislodge those who have been appointed without giving them an opportunity of being heard. Therefore, despite finding that some illegality has been committed by the respondents in undertaking the selection process for the post of armed branch constable, this court refrains from interfering with the appointment already made. However, at the same time, having come to the conclusion that the process of selection was arbitrary and beyond the terms and conditions that was indicated in the advertisement, I am of the considered view that petitioners have also made out a case for the following direction. Yes. Page 222. The respondents are directed to consider the case of the petitioners for their appointment to the post of armed branch constable or in any other equivalent post in vacancies available current or next available vacancies. If vacancies are limited, petitioner will be considered in a phased manner till all of them are considered. If it is found that the petitioners in the meantime have become overaged, respondent authorities shall give them age relaxation as may be required. It is made clear, respondents without considering the case of the petitioners shall not fill up any post of the armed branch constables. So rightly or wrongly, my lord, there is a judgment which is in our favor. Now, my lord, what happens? Pursuant to the judgment, an order is passed by the authority in the next page. Page 223. Whereas WPC number so-and-so was filed by 167 petitioners of Sibsagar district, challenging the selection of candidates available for appointment as AB constable pursuant to the advertisement dated 2209 for recruitment of AB constable in Assam Police in ONGC in vacant post of different battalion. Whereas Guwahati High Court by order dated issued the following direction. Now these are the three directions, my lord. Now please come to next page, page 224, Roman 3. It is made clear that respondents without considering the case of the petitioner shall not fill up any post of the armed branch constable. So this was the direction of the court. Now this is the finding. Whereas report regarding selection of AB constable pursuant to advertisement dated so-and-so held in Sibsagar district in the year 2009 and 10, and recruitment data has been collected from the chairman, state level recruitment board, and the report reveals that 156 number of posts were allotted to Sibsagar district, out of which 8 posts, 5% were reserved for appointment on compassionate ground, and therefore recruitment for 148 posts of AB constable was conducted in the Sibsagar district pursuant to advertisement dated so-and-so. All the total 142 candidates were selected category-wise. The report received from the chairman reveals following recruitment information against each of the petitioners in so-and-so. Perhaps you can resume at 2 o'clock. May it please allow. I was referring to that order of 21st of October. 2019 passed by the, appointing authority pursuant to the order of the learned single judge.
That is at page
224, 223, it refers to the three direction of the learned single judge.
Yeah.
Then please come to the sentence starting as whereas.
Whereas the Honorable High Court following direction.
Yes,
Yeah,
page 224, my lord, next page.
it is made clear.
Whereas this third sentence of 3, whereas report regarding selection of AB constable pursuant to the advertisement dated 22/2009 held in Sibsagar district in the year 2009 and 10, and recruitment data has been collected from chairman, state level police recruitment board Assam, and the report reveals that 156 number of posts were allotted to Sibsagar district, out of which 8 posts, that is 5%, were reserved for appointment on compassionate ground. And therefore, recruitment for 148 posts of AB constable was conducted in Sibsagar district pursuant to the advertisement dated 22/09. All total 142 candidates were selected category-wise. The report received from the chairman, SLPRB Assam, reveals the following recruitment information against the petitioner of WPC number so-and-so. Now, from page 226 to 238, my lords, it refers to the petitioners and they're trying to justify why selection was not done. Then please come to page 239. The Guwahati High Court passed order dated 22/2/19 directing respondents to consider the appointment of the petitioners for post of AB constables in any other equivalent post in the vacancies available. From examination of the report received from the chairman, state level police recruitment board Rehabari, it is found that some of the petitioners either did not apply for the recruitment test, did not appear in the recruitment test, failed in any of the physical efficiency tests, failed in viva voce interview, obtained marks less than cutoff mark for which they were not selected. Therefore, the petitioners did not come under the zone of consideration for appointment as AB constable. It is also mentioned that performance sheet of the candidate containing signature of even in charge and one of the member of the selection committee were signed by them and also by candidate. This disposes the writ petition order dated so and so. My lord, what was required in terms of the order of the learned single judge was not to go back to the selection and find out whether the petitioners merit consideration or not. In our humble understanding, my lord, the direction was, since there were irregularities in the selection process, though we are not interfering with the selection process, their cases is required to be considered. Now, my lord, that we have failed, that we did not pass, I'll show from their own record how they are wrong. Here is a selection where the Omen reservation cutoff mark was highest, is unheard of in this world. They do not even understand what Omen reservation is. When we challenge this order before the learned single judge, now kindly see, my lord, how single judge, as if the learned single judge in the impugned judgment under appeal was sitting in appeal over the earlier single judge's order. I'll just refer to that, then I'll come to the facts. Please come to page 340.
Mr. Chaudhary, leaving aside who gets what benefits, if we might ask you, what is your opinion on the legality of the directions even in the earlier judgment?
No, my lord, I also thought it over. Now we find in medical admission matters, Honorable Supreme Court has said that even a particular selection year, something is wrong done to a candidate, then without disturbing the selection already made, direction has been issued to consider in the next case.
142. That's under 142.
True.
What is the power of the High
No,
Court?
no, those are not necessarily under 142. Those are under Article 32 also, the decisions are there. True. No, what I'm saying is, if our consideration was wrong, are we not entitled to a fair consideration? That boils down to that. Now, I'll satisfy your lordships. Prima facie, by showing some instances. For example, I fully appreciate what is fallen.
We are assuming that.
Hmm.
There is no, whatever you are contending regarding this, your consideration, is certainly the petitioner's consideration or the appellant's consideration was not in accordance with law.
Yes.
That was there.
Hmm.
That was there, but coupled with this fact, this direction issued by the learned single judge in 2022.
2019. 2019.
19, I'm sorry. That direction seems to be.
Pilot will kindly come to page 79. This was our writ petition, paragraph 12. Please have a look at this. No, my lord, this selection was really not in accordance.
No, that's true. That's true.
That has to be accepted.
But we are always concerned about the principle.
True.
That is of paramount importance.
But
Otherwise, the orders
but
become
the fact
arbitrary.
that some wrong was done to us,
Yes.
in some manner, lordship will have to compensate us. In some manner. May not be in the manner as has been directed by the learned single judge.
The cost.
That if the learned single judge was of the view that there was illegality in the selections, the only course was available with him to quash that selection and pass the consequential orders, not in this manner, without disturbing that, adjust them in the future vacancies or any other, in any other department, in phased manner even. These directions to be.
But then rightly or wrongly, it will against the appeal position.
Neither the state nor the petitioner have assailed this order on such count. Now, at this.
No, I was only trying to show to your lordships how our, rights were,
So, Mr.
interfered with.
Mr. Chaudhary, we want to put you on notice on this count so that there may be arguments. But we find that the order passed in 2019,
The first petition.
the criteria that has been adopted, that is not in consonance with the legal principles. So therefore, subsequent order is where you are pressing your rights flowing from that order. If we are prima facie satisfied that that order, the principles on which it was passed, is not in accordance with law, as a division bench, we can make an observation.
What I'll respectfully submit, my lord, maybe not in the form as has been articulated in that order.
What is the principle? Don't disturb them, appoint them also. Show us a judgment where it has been done. In appointment, it's not admission.
No, in future vacancies, our cases can be considered by giving us some weightage.
How can it be? What about the future applicants?
No, future applicants are there. But in an extraordinary situation, lordships can mold the relief. It's not that.
142, where 142 place comes.
No, I am not saying 142. I'll show certain instances. Lords will kindly give me that opportunity. I'll show few instances how the wrong has been done to us. That I'm trying to show from their own records. 105. Please come to page 105.
But you have got the point, no? That wrong has been done. But the remedy is not what was.
In what manner it can be enforced? Yes.
Unless.
Please come to 105. Now, this is the part of the affidavit which was filed by the state. These are page 105.
Yeah.
Now, these are the position of the petitioners.
Female candidates.
Yes, first page is female candidate.
Yeah.
Pinky Borgohai, she secured 70.05, so she was not appointed. Rumi Gogoi, she secured 70.05, not appointed. Poppy Kaur, 73.05, not appointed. So this is how it was done. Now, for a moment, if your lordship would kindly come to page 101. Now, this is how appointment was made. Case করে অলপমান চাইনিজ কৰিব লাগে এনে কেস কৰিলে হৈ যায় নেকি Para 8.
Yes.
Kindly come to somewhere in the middle. The minimum cutoff mark for general has a lordship's got that. In para 8, somewhere in the middle. Yes, minimum cutoff mark for the general category was 68.05 for SC. It was 63 for STP. It was 65 for OBC. It was 66. And for women, it was 74.5. Can we imagine, my lord? If for OBC it was 66, now please come to page 105. I am OBC. This Pinky Borgwai is OBC. She is appellant number 6. So she should have got. She has got 70.5. Similarly, please come to serial number 2. Rumi Gogoi. She is appellant number 7. She should have got. Poppy Kaur is also not before lordship. Then serial number 7. Rupjuti Setia, she got 74.5. She was not appointed by their own thing also. She should have got it. She is appellant number 4. Then Poppy Moni, serial number 8, she should have got. She is 69. Then please come to serial number 10, Khewali Pegu. She got 64. She is appellant number 31. And for STP, it was 63. She should have got. Then please come to Moon Kumar Bora, 65, appellant number 9. Then serial number 12, Mitali Hadhonidhar. She got 69. She should have got. Nitu Dole, 67. She should have got. Buli Borwa, 70. She should have got. Nandita, of course, different. Then Songita Morar, she should have got. Ankita Borwa, she should have got. Now, these are the selections. How do we overlook these, my lords? If lordships can take judicial notice of the fact that the learned single judge's observations were wrong, these facts also can be taken note of. Notices should go to them now. These appointments should be cancelled. And you see, my lord, women reservation is an horizontal reservation. It is not vertical reservation. My lord, we have indicated the position, how many petitioners were deprived, that we have given. If your lordship would kindly come to page 186, we have given category wise from 186 to 190. 186 para 5, it was our affidavit. That in respect of the contention made in paragraph 3 of the connected additional affidavit, the answering deponent begs to state that from records which are annexed with the said additional affidavit reveals that selection authority was, after completion of selection process, set up fixed certain benchmark for each and every category of candidate for selection. Although no such benchmark has been fixed in the advertisement, and the guidelines. The said benchmark was fixed after selection process was over, which amounts to changing the rules of the game, and the said is not permissible as per law. That apart, the said benchmark was fixed by selection authority with a policy of nepotism for extension towards near and dear one of the officials under some vested interest. And accordingly, selection authority provided higher marks to their blue-eyed boys and girls above the benchmark and discarded others who did not meet the demand for officials, including the petitioners. But in doing so, selection authority also made mistake. Now kindly see, I have given a chart. Now, petitioner number 93, she got 69. Petitioner number 4, 70.05. So these are the marks. So by their own, cutoff mark, these petitioners should have got the job. Then please come to page 188. By the cutoff marks set by them, we should have got. In STP category, these two petitioners should have got. Then in SC category, these petitioners should have got. In OBC and MOBC category, these petitioners should have got. That apart, the opponent further begs to state that the benchmark which are fixed by the selection authority also not maintainable as per law. The list which is annexed to the affidavit shown that minimum benchmark for women category is 74%, whereas minimum benchmark fixed for general category is 68, lower than the benchmark fixed for open category. In this regard, it is pertinent to mention here that benchmark fixed for reserve category cannot supersede the benchmark fixed for general category. That apart from the additional affidavit filed by the respondent number 5, it is discernible that 142 number of candidates were selected in the selection process carried out in Sibsagar district. But in the said affidavit as well as in the earlier affidavit, nothing has been mentioned about the vacancy position in the district. So my lord, my humble submission is at least these petitioners are by their own showing should have got the job. Now these facts are before your lordships. Would your lordships refuse to interfere? That's the issue. Prima facie. And my lord, where on earth the women reservation benchmark can be 74.5? My lord, supposing in a given, supposing the cadre strength is 100, say in Assam for plain tribal it is 10. So if within that 10, within that 100, 10 women are there, then there is no scope for invoking horizontal reservation. If there is, let's say there are 7. So from down below, 3 will chip in. So that is how women reservation is made. Now they have made out a different category. Well, at least these petitioners, these appellants, they're entitled for some relief. If not the whole 142. If necessary, lordships will issue notice to them. Before the learned single judge, no notice was issued to them. Now they are before your lordship.
Notice to whom?
The persons who are selected, some of the selectees notice will have to be issued because they'll have to be heard. Even on the party person. Case for a Nasana. I can question notice. Yes. Milord will kindly come to for a moment, page 144.
Yeah.
This was the so-called select list, which was annexed to that order pursuant to the order of the learned single judge in the first round.
Yes.
Now, please come to serial number 39.
Dimple.
Dimple Dihingia. Kindly see, my lord, what is her mark? 71.
She has been appointed.
She has been appointed. Now, the appellant number 4, she secured 74.5. And one Poppy Kaur, who is not before your lordships, of course, she secured 73.5. Appellant number 4 secured 74.5. So there are at least 16 appellants before your lordships. Apart from this Poppy Kaur,
And after passing of this 2019 order, now they have justified their non-selection by giving reasons in that order,
yes,
impugned order.
yes. But the requirement was not to re-verify the merit list and publish an order. The direction was, we are not disturbing their, consider our case. That is one legality of that lordship. At least, my lord, to the extent of these 16 petitioners, let notices be issued to them, my lord, let them appear what they have to say. At least 16 from the bottom will have to be interfered.
So, Mr. Majumdar, appoint them.
Hmm.
You have not preferred any appeal against the judgment of 2019.
But I show why we have not appointed. And this benchmark, cutoff mark, this issue has become settled by the order passed by the in 2019. There is no appeal against that. This issue was raised in that petition. The honorable single judge has clearly held that it is permissibly relying on a judgment which I relied minority before the honorable single judge. I'll come to that. I would like to proceed in a slightly different way, right? Because there are two appeals made. Lords, may I kindly have a look at this small thing. Yes, okay.
Yeah.
Just a summary of these two retailers, madam.
Yes.
20th of February 2009, the advertisement for recruitment of 2,401 posts of constable AB armed branch, which included 154 posts earmarked for Chief Sagar district. August, September, October 2009 selection process completed. 1st of April 2010, select list published by state level police recruitment board. 7/5/2010, WPC number 2725/2010, Kolash Fukan and 166 others filed challenging the select list. Since there was no interim order in the above petition, the selected candidates were appointed. 22nd February 2019, WPC number 2725/2010, disposed of directing the state respondents to consider the case of the petitioners where the appointments of selected candidates were not disturbed. 21/10/2019, pursuant to the order dated 22/2/2019 in WPC number 2725/2010, the Director General of Police Assam passed a speaking order holding that the writ petitioners did not qualify and accordingly not entitled to be appointed, which is under challenge in the present writ appeal by them. 13th of March 2020, 3 writ petitions were filed, my lord. WPC number 2725, number is same, but the year is different. 2020, filed by Brojen Bora and 3 others, praying for quashing the subsequent, my lord, advertisement dated so-and-so, addendum dated so-and-so, and also another advertisement dated so-and-so. And the second pair was direct respondents to comply with the order dated 22/2/2019 passed by the Honorable Court in writ petition 2725/2010 to consider. And there was a second writ petition by Biswajit Gogoi and 129 others praying for similar relief as the above number 1. Number 3 is WPC number 4133 of 2020 filed by one Rumi Gogoi and 133 others praying for quashing the speaking order dated 21/10/2019 passed in pursuance of the first order passed by in the petition and stay the recruitment process pursuant to advertisement date 25/4/2018. On 8/10/2021, WPC 4133/2020 filed by Rumi Gogoi and 133 others was dismissed on merit after hearing the parties. And then 8/11/2021, writ appeal number 323 of 2021 was filed asserting the above judgment in order dated 8/10/2021 in WPC number 4133/2020. And then the state has filed this writ appeal number 50 of 2022 filed by the state against the judgment and order dated 22/2/2019, the first order, my lord, in WPC number so-and-so. Although in compliance of the aforesaid judgment and order dated so-and-so in WPC number 2725/2010, the speaking order was passed, yet the state has filed this appeal as the respondents are praying for compliance of the said order in the connected writ appeal number 50 of 2022, which prayer was rejected by the Honorable Single Judge in WPC number 4133 of 2020. And also because there are some observations about illegality in the selection process. Now, before I respond to the writ appeal filed by them, I'll take your lordship to the writ appeal filed by the states to show how the observation or the direction passed by the Honorable Single Judge in the first writ petition to consider the case was absolutely illegal. And 2 issues were framed. The challenge to the selection process.
You preferred an appeal against the 2019 judge. Where is that?
This is the writ appeal manner, writ appeal 50 of 2022.
Today it is listed.
Yes, manner. Both are tagged together.
But you have already complied.
I have complied, but still I am challenged. There are 2 I have indicated in this list of dates, my lord. One, in the present writ appeal, of course, they are still relying on that observation that kindly consider their case. My submission before lordship, my lord, in view of the fact that the findings were recorded in favor of the state and against the writ petitioners, there could not have been any direction to consider their case again.
Very well, but you have complied with the direction.
I have complied with the direction so far as the consideration is concerned. But my
That's the only direction.
But yes, my submission before lordship, even the writ appeal filed today, they are relying on that observation. That is why I say, my lord, that observation is not correct. And I'll show, my lord, how it is not correct. And today, my lord, still they are challenging in the
It's like saying the accused could not prove his innocence, so he should be convicted and sent to jail.
That's why I said.
That can't be the argument.
That's why I said, my lord, I am challenging the finding there. I have complied with the part to consider, but they consider there are 2 things, my lord. We have made the consideration in pursuance of the order to
In fact,
show.
you have filed that appeal since these persons have filed this writ petitions seeking compliance of that order.
Yes.
Therefore, you have filed that.
Yes, my lord. There is a reason, my lord. Because the observation or the direction to consider the case ought not to have been there.
Or not to have said that, why you have considered and rejected them in nature?
I have considered not for the purpose of appointing them. The interpretation sought to be given today is that the observation
Yes,
consider.
That way is right. That there was no question of reconsideration of their merit.
Yes, I didn't read.
Since the learned legal judge simply said that appoint them, either to comply with them or to challenge them.
My lord, the direction to consider, we have, my lord, assumed that the direction to consider is to see whether any of them has qualified to be selected or to be appointed or not. And we have examined the marks and we saw that none we have not made any re-evaluation, my lord. We have only have taken out the marks obtained by them and compared it with the qualifying marks benchmark. And benchmark is there. And why there is a different benchmark for women, for OBC, well, there is also a reason for that. I'm just pointing out to you, Lordship. My Lordship will kindly permit me to show in my appeal why this consideration is illegal, my Lordship, for a moment. My Lordship may kindly turn straightway to page 316 of writ appeal number 50 of 2020. My Lord, with all respect, I'll submit the almost single judge in that case has come to an abrupt finding that there is an arbitrariness. Almost single could not show what is the arbitrariness. There is nothing.
Why have you implemented that order?
We did not implement.
This is a case of,
My
clear
Lord,
case of.
there is a
escrow
difference. There is a difference in implementing the order to appoint them and to examine whether any of them has actually secured marks more than the qualifying mark or not. Lordship may kindly see page 317.
If this is permitted, it will run down the entire system. Everybody will implement the order and also appeal it. What is the point? It was not done with the leave of the court. Now, what is the purpose of this appeal? We have to go into the merit.
No, my Lord. I'm only sure. My Lord, there is a reason why we have filed this appeal. Even in the present appeal filed by them against the subsequent judgment passed in the subsequent writ petition, my Lord, they are again relying on the same observation. That is why I'm trying to show that the observation to consider was not correct. That is the reason, my Lord. Because in the writ appeal filed by the private respondents now, my Lord, they are not challenging the speaking order as such on merit. What they are saying is, since in the original writ petition there was a direction to consider, you could not have done any exercise, you should have straightway appointed us. That is the reason for which we have preferred the appeal. Lord, may I kindly turn to
But
page-
you have understood the point, no?
My Lord,
What we are indicating.
I've understood, my Lord, once it's correct, my Lord, that if we comply with the order, there is no necessity of filing an appeal against that order.
No, not necessity. You
Right.
cannot.
Yes.
That's not permissible.
I'm just.
Because an order which has spent its force on being implemented cannot be reopened by this court. That's the simple logic. Even if we find that Leonard Single Judge was wrong, we cannot undo the exercise conducted by the authorities. Now, the only question will be whether the exercise is rightly
True, my Lord. Now
rightly
I'm.
deprecated or not by the Leonard Single
My
Judge.
Lord, now I am showing the judgment of the single judge passed in their case to counter their argument in this appeal which they have.
That's okay.
My Lord. Page 316, my Lord. Page 316. Because the whole basis of their writ appeal is that there was a finding that they should be considered. That is why I'm showing that. 316 of my appeal, man. This judgment is available there also, but I'm showing from here. No, yeah, I got it. Side. Side doesn't make nothing part of it. I don't think we think that they are. There are 10.
Yes.
I'm showing from. Lordship, that judgment is available in this retape also filed by them at page 216, my lord.
That
Page-
19 judgment?
My lord,
Yeah, that is there.
my lord. Para 10, my lord, two issues were raised before the learned court, my lord. That because of reservation in favor of women to the extent of 10%, the selection is bad because under the act, there should have been 30%. This was turned down in paragraph 10, saying that you have participated without challenging the advertisement. Secondly, my lord, para 11, about the cutoff mark. My lord, I relied on a judgment of Yogesh Yadav of 2013-14 SSC, page 623, to show that introduction of a benchmark does not amount to changing rules of game as alleged in that writ petition, my lord. And this finding is at para 11, page 220, Lord, you may kindly have a look, man. Page 220, para 11. I'd like to read that paragraph.
Yes.
Adverting to the other issue as to whether respondents have changed the rules of game by adopting methods which were not reflected in the advertisement, the stand of respondents, as can be seen from paragraph 8 of the affidavit in opposition dated 22/7/2010, is clear. Minimum cutoff marks have been provided for each category of candidates, that is, the reserved and unreserved. Although same is not reflected in the advertisement, but the fact remains that in order to select the required number of candidates for the posts advertised, the participating candidates will have to be arranged in order of their merit, and therefore a cutoff mark will have to be arrived at. As may be seen The advertisement provided that a merit list will be prepared on the basis of aggregate marks secured in both the physical test as well as viva voce test by the candidate in accordance.
My lord, to save your lordship's valuable time, this is not even our case.
This is not even a case, and in fact, these observations are strictly in the.
Facts of the
How
case.
can you create a separate category?
My lord,
That is absolutely.
my lord, so far as
Mr.
creating,
Majumdar,
my lord,
please don't go deep
My lord.
into it, otherwise you will be in trouble.
my lord,
Please don't go into deep.
my lord, as far as making separate category of my lord, benchmark for different category, my lord, for women, the tests are different. They have to run for a
Then create a separate class for them. Can't do that. That is. That's all.
My lord, my only submission is, by way of reply, my lord, my learned friend has referred to para 10 of the judgment. There the issue was regarding 10% and 30%.
yes.
That the benchmark for women category will be 74.5. I don't think my learned friends would support that stand. That can't be. Let us say it can't be.
No, it can't be. And
So therefore,
secondly,
my only submission is, my lord,
secondly, these are all prescription of statute.
yes,
Knowing well if someone participates, that
Yes.
cannot waive. There is no
that cannot
estoppel
be an
against statute.
estoppel.
There is no estoppel against statute.
Well,
My lord,
that,
for-
my lord, therefore, my submission is, for a lordship's kind consideration, at least to the extent of the 16 petitioners who admittedly by their own showing should have been in, something has to be done.
Will consider.
Yes, yes.
My order is the,
Page 139 will be of some relevance as far as this separate
There
bench.
is no relevance at all, please.
But Mr. Majumdar, please advise your clients, the state. They're either they should appeal or they should comply with the order. Not a middle path.
It's something like, my lord, পিলারের মধ্যে কয়টা L? One also does. If there are two L in the
becomes
word,
stronger.
it becomes more strong.
Item 61.
Well, I think
Party number.
deeply.
There is again changes in the section 21 Assam amendment.
Okay.
And during pendency of this writ petition, there are various changes and some of the prayers become redundant.
So
I
file
have
a
to-
fresh petition if you are, if you advise so, file a fresh petition by withdrawing it.
My lord, I can file a amended.
It's
petition.
better if you amended writ petition, then again it may come, file a fresh petition, we'll grant you the permission. In view of the subsequent amendments, you can file a developments or amendments or whatever it may be, you may file a fresh petition, we'll allow you to do. Okay, learned concept of the petitioner has submitted that in view of the subsequent developments, he needs to reframe his claim by filing a fresh petition. The petitioner needs to reframe his claim by filing a fresh petition. Therefore, he may be allowed to withdraw this petition with liberty to file fresh. So dismiss with liberty as prayed for.
Item 62.
My lords, I'm praying for a short accommodation. Mr. Pathak has to leave early, my lord. Due to his personal difficulties.
Yes. Adjourn, summarization.
Obliged, lordship.
Item 65 to 67.
May it please the lawsuit.
Matter was sent to mediation.
The mediation has failed, my lord. As per our information, the mother-in-law is not cooperating. It is a clash in between the mother-in-law and daughter-in-law.
Not new. Not a new one.
Daughter-in-law, my lord, she lost her husband while he was in service. So,
The mother-in-law lost her son.
and the mother-in-law lost her son. Now the daughter-in-law filed a petition for her compensation appointment. They objected it that she the divorcee, she cannot.
See?
That she is a divorcee, so she cannot get it. This plea they raised, my lord. She filed an application before the CAT, my lord, Central Administrative Tribunal, that I should be given the family pension, this thing. It was, however, considered. She is given allowed the family pension.
But terminal
it-
benefits are allowed to.
and my other materials are to the mother, my lord. So she came here before this honorable court that I am given the family pension and the other pension and benefit also should be divided in between us. The mother-in-law is all along objecting, stating that she is a divorcee, she cannot. And this plot of divorce she has brought in a very manipulated way, my lord. The husband died, my loss. He died on 6/8/2017. And allegedly, the talak was pronounced allegedly on 1/1/2017. And it is been communicated to the wife on 15/8/2017. That is, they are telling that the pronouncement of talak was done on 1/1/2017. He died on 6/8/2017. In between this period, there was no communication. After she having filed these cases, my lord, they are manipulating a plot that on 15/8/2017, she was given divorce by her husband. And that
So mother was dependent on the son?
my lord,
Was the mother dependent on the son?
no, my lord. She is a pensioner. She is
Mother-
getting a
mother has
family pension. Her husband was working in the central government department. She is getting a pension. She is drawing her family pension. And my lord, they allege, interestingly, my lord, I beg to draw your lordship attention. They are all along clashing with me that I am a divorcee, I cannot get family pension. And this matter has been fought before the CAT since the year 2018. Now in 2022, they have filed a petition, a suit before the Munshaf Court in Nagaon district, seeking a degree for divorce.
The husband is already dead.
My lord,
Husband is already dead.
he did wrong back. Now mother-in-law is, my lord, I may place it before a loss as well.
Nomination. Only purpose to disburse. Not appropriation. Appropriation, you have to find it out in the same code. You will have it. Look at that. So, Mr. Rajbhavia, it seems the mother was the nominee in the official records, right?
Before her marriage, my lord, before the marriage in between the husband and wife,
Right, but that was not changed.
that was not.
So
That's it.
this is the law, and after that, you can come up with your arguments. The authorities will have to go by the nominee. But nominee has the right to receive the amount but not to appropriate. Whether mother is entitled to appropriate or not, that is another matter. So if there is a dispute on that, it has to be resolved in the civil court. That's how the law operates. Rest, you can make your submissions. Your client can get a declaration from the civil court that the divorce was illegal. There was no such divorce. The mother doesn't have any right, and you have the right to appropriate the amount and a decree to part with the amount. That is a relief you can get from the civil court, but not in the writ court. The learned CAT has passed an order in equity, but it is also based on the nomination. Therefore, it's not an order which deserves interference in the writ petition. Now you can make your argument.
So my contention before the losses, my lord, they are raising the plea that she is a divorcee. The marriage was
You have
solemnized.
just heard. That is a declaration you have to seek from the civil court. We can't say.
Yes, my lord.
Yes, whether the divorce is genuine or not, we cannot make any comment here.
And in fact, this question was never raised before was not before the CAT.
Yes.
In fact, before the CAT, you approach the CAT with a prayer, issue a direction to this respondents to consider the case or family pension and other service benefit under the relevant central pension scheme.
Yes.
This
yes,
was
my-
your relief.
Yes, my lord.
And this tribunal, after considering the same, has ordered that family pension be allowed to you.
Yes.
But as per the nomination, the familiar benefits are to be given to the mother. That's all. Mother of the deceased.
So for the.
Whether the mother is entitled or not, for that, as brother has suggested, that you have to approach the civil court for that. Only you are entitled, or mother-in-law is entitled for so much of share or whatever percentage of share. For that can only be adjudicated by the civil court, not by this court.
So civil suit is pending before the court, my lord.
For that reason.
So for
What remains, sir? Then what relief you are seeking?
Title suit has already been filed by the mother and that is pending, lordship,
so my
regarding the divorce part.
my
That
contention
divorce
yes.
part we are not concerned.
Lordship, that is a separate thing.
my contention before your lawsuit is that, my lord. In the before the CAT and before this honorable court also, the mother-in-law is telling that I am a divorcee.
We are not going.
And allegedly in 2017, her husband, little before his death, he pronounced divorce. Now, if it is the fact, my lord, why she has filed a suit in 2022 seeking a degree for
That you have to
divorce?
ask her. We can't say. Why she has
So
filed a
the
suit?
story of divorce, and interestingly, well, the story of divorce is that after the death, they are making affidavit before the Qadi in Nagaon district, where her son was serving, that allegedly two persons went to the Qadi and told that Mr. So-and-so was our friend, and before his death, he pronounced divorce to his wife. And basing on this, so wanted to get a degree of divorce from the Qadi. The Qadi did not, I cannot give any such because there is no record of divorce. And the matter is before the civil court, my lord. Now, why the CAT also allowed me the family pension, and over and above, by an interim order of this honorable court, I am allowed to continue the family pension, which I am now getting, my lord.
Interim order dated?
Interim order dated
My lord, it is in WPC 2914 dated 3/5/2021. In WPC 2914, my lord. Nomination.
Yes. So whatever the contention of the mother-in-law, that was specifically rejected by the cat.
Yes, it was rejected by the cat.
So then why you are raising again this plea, sir? What's the point in raising this plea that they are claiming that she has been divorced and nothing else? That has already been ruled in your favor by the cat.
This is there, my lord, but our contention before the lawsuit, the family, it's cat has given us the family pension.
Yeah.
Other part of the pensionary benefits are not given to us. So we wanted it should be also
That
given.
finding is
Not
based on,
entirely, but it should be divided.
it should be divided, then you should approach the appropriate civil court for that.
Then it is after the lawsuit, the lawsuit may be pleased to direct us so that we can approach.
Why 3 writ petitions?
Lordship, item
No,
67.
3 writ petition, my lord, these are all related because we approach your lawsuit
How
against
they
the.
are related? Tell us.
Lordship, item 67 has been filed by the mother-in-law. Lordship, we had
67 mother-in-law.
Lordship, yes, Ambia Begum, Lordship, writ petition number,
Against this relief of granting family pension.
Lordship.
Against cat order to
Cat order.
petitions. Both had filed to
And
petition.
this third petition is?
One is
2914 has been
for
filed.
compassionate appointment. The brother of the deceased had filed this for compassionate appointment.
Yeah.
This Rehana Begum 3091/2021 is against the cat order.
Against the cat order.
Yes, my lord.
And this
Again,
1886/2020 is it is against which order?
against the mother-in-law filed against the cat order. She wants that she should get
Rehana Begum is the
wife. Rana Begum is wife, Ambia Begum is mother-in-law.
so this Rehana Begum petitions two. One petition is against the cat order. Another petition is
Lordship.
No,
they-
first
Lordship,
one
they
she
issued-
filed, my lord. First one she filed, that let me tell. 1886, she filed before this honorable court might against the cat order because cat's order because she wanted, she made a prayer for compensation reformment. That was not considered. So he approached this honorable court, my lord.
Lordship, there
The
were
second one she filed, the cat has given her the family pension. And other part, it is pensionary benefit is entirely given to mother-in-law. So she approved this code. Yes, I am given the family pension. And other part also I should be given divided.
So that is writ petition number?
It is writ petition number 3091. And the third one filed by mother-in-law 2914, that is, I should not get anything.
Direction to appoint that on compulsion. That was declined. So we find this. Only 1 area. We have very bad. Proceedings are family pension.
Nomination of
family pension is दिया है उसके वजह से ये फैमिली पेंशन जो दिया है उसके वजह से One eight eight six, it will also report to 1886.
Yes.
My lord. So we leave it before the losses, my lord. That is, she is a wife, she should be given her family pension and also the other benefits.
Family pension, but that has already been ordered.
Oh, of course.
Yes.
Lordship 2914 of 21 has been filed by the mother-in-law. Lordship, on the premise that Lordship in the earlier round of litigation before the Honorable CAT, which is under challenge in WBC 108, therein the wife had claimed compassionate appointment. Honorable CAT came to a finding that the status of the wife, we are not able to determine that, and therefore we are not interfering in it. Now, Lordship, in the second round of litigation, wherein she had claimed pension and pensionary benefits, herein the Honorable CAT came to a finding that she is the wife. Now, Lordship, two contradictory findings have been arrived at by the same tribunal. Now, Lordship, and as regards the issue of determination of her status, that issue is pending in the title suit filed by the mother-in-law. That they have been made party and they have already approached the Honorable High Court. They have obtained the stay. That is a separate issue that the Honorable Court will take. As regards the pension and pensionary benefits, Lordship, Honorable CAT came to a finding that I have been entered as the nominee of the late employee. And therefore, terminal benefits may be given to me, but the CAT on its own arrived at a finding that since she is the wife, pension should be given to her. Now, Lordship, that determination is entirely within the jurisdiction of the civil court.
Fine. That's all. Sure.
That is my own submission. Obliged.
Close for honors.
Obliged.
Much obliged.
Item 68.
Record was called for.
Yes, here.
Record was not available since I forgot to inform them lots of.
Not available.
Not available, Lordship.
Available is not at all.
Not available
or-
with me, Lordship.
No, you have failed to procure it.
Lordship.
So you'll produce the
Lordship.
record in what time?
Yes, Lordship.
When?
Next week it may be fixed, Lordship.
After 2 weeks, my lord.
Adjourn.
Date maybe.
Okay, after summer vacation, we'll give you the date.
We'll allow CBC to produce the records.